Let's turn to jury instructions. I know counsel want to resolve them so that you can complete your preparation for your arguments. The court has received from both the defense of Eric Menendez and from the defense of Lyle Menendez written memoranda relating to the issue of self-defense. The prosecution has filed no brief. Other than what the defense has put in writing, is there anything else that you want to state to the court on the subject of self-defense?
I, for one, would like to hear what the position of the prosecution is, since they didn't file any responsive pleadings. I'm unclear whether they are still objecting to unreasonable self-defense or whether the objection is just to perfect self-defense, and if so, I'd like to hear what their position is.
I think that's an appropriate request.
Yes, Your Honor. Having relied on the Aris case, I think that I find a logical flaw in the Aris case, but that does not invalidate my reliance on it for self-defense, but would invalidate reliance on it for imperfect self-defense. In other words, I think that one of the distinctions Aris makes is about the use of the term imminent, but I think more correctly, it's the people's contention that there has been insufficient evidence that would meet the objective criteria for perfect self-defense. And I believe that Aris, and I think the court indicated the court would so instruct the jury, indicates that the psychological testimony is not relevant to the issue of reasonableness, but rather only goes to the defendant's belief. And therefore, it's the people's position that under Aris, which upheld the trial court's refusal to give self-defense instructions, the people would encourage this court to refuse to give perfect self-defense instructions. However, it's not our position that the court should refuse to give the imperfect self-defense. And although it would be an attractive argument, I don't think that it's intellectually honest to so argue, because the unreasonableness goes to lots of different factors, including the perception of imminence. And so insofar as Aris's discussion of imminence in terms of the giving of the self-defense instruction, I don't think that that is the correct reason to refuse to give the self-defense instruction. I think the correct reason is that there's insufficient evidence upon which any trier of fact could find that the defendant's perception of danger was reasonable. But in terms of unreasonable self-defense, I think that it would be incorrect for the people to say that Aris supports the people's position that imperfect self-defense should not be given as well.
Well, in light of that concession, Your Honor, it now seems to be the case that the prosecution is conceding that there is sufficient evidence in the record from which a jury could determine that Lyle Menendez and Eric Menendez had a subjective belief in the imminence of a threat to their life, or a subjective belief in the imminence that they were going to cause some great bodily injury by the parents.
They're saying there's sufficient evidence for the jury to decide that issue.
Correct. That's what I understand that concession to mean. And given that, it seems that the only issue left for consideration on the question of perfect self-defense is whether there is any evidence in the record to justify a reasonable person in the same circumstances as the defendants were in, and that would take into account the entire history that was put before the jury, had reasonable cause to believe that they were in fact in imminent peril to life or great bodily injury. And as we pointed out in the memo, the standard here under Flanell is that doubts as to the sufficiency of the evidence to warrant instruction should be resolved in favor of the accused. So it seems under that standard, the court has to be able to say, there is no doubt in your mind that there is insufficient evidence in this record. There has to be no doubt, otherwise the balance goes to the defendant and the instruction should be given. And just stepping back from the issue for a moment, it seems unwise from the prosecutor's standpoint and some sort of concession that they really don't trust the jury system to be taking the position with the court that the court should withdraw this issue from the jury, because if in fact the evidence is so weak that it could not possibly justify an instruction on that, then it should be equally weak enough that the jury will reject the defense under appropriate instructions. And all the cases we cited to the court point out that if the court erroneously refuses to give the instruction on self-defense when there is any evidence in the record to justify it, it is reversible error per se. And it's reversible error per se because such an instructional error implicates the defendant's federal constitutional right to a jury trial. So the people are willing to gamble that in this case, after all the testimony we produce over a period of 5 months, that an appellate court will say there is no evidence whatsoever deserving of consideration in this record which would justify a self-defense instruction. And if they're wrong about that and the court takes a gamble and refuses to give the perfect self-defense instruction, then what we've been doing here for the last 5 months is for naught, because the case will have to be reversed. And if the court, on the other hand, were to play it safe and to give the instruction, the worst that could befall the people in that situation is that the jury would then be confronted with the task of determining under appropriate instructions whether the evidence was sufficient to sustain the defense of perfect self-defense. It still leaves the people open the option of arguing to the jury that under the court's instructions, that defense is not substantiated on the evidence that has been presented. And it seems that although the prosecution is willing to take the risk in the circumstances of this case, that we'd urge the court to be a little cautious on that score, because the implications of erroneously denying a self-defense instruction in this case. And in that regard, I think it's important to point out to the court that this is a case not only in which the defendants and their witnesses testified to a history of abuse and the experts explain the history of abuse, but there is specific evidence in the record that threats to kill the brothers were made under circumstances very similar to what occurred immediately preceding the homicide. Because there was testimony by Lyle Menendez that at age 13, when he had the discussion with his father concerning sex with Eric, that the father told him, "We should just keep this between us or I'll kill you." And then later on, there was testimony concerning an incident with a tennis instructor, I believe it was Mr. Klaus, where Lyle Menendez apparently embarrassed his father in front of Mr. Klaus. And after threatening to kill Mr. Klaus, Jose Menendez said to Lyle Menendez, "If you ever embarrass me like that again, I'll kill you." And the phrasing of that threat to kill becomes significant when the court then turns to the evidence concerning the discussion Lyle Menendez had with his father the Thursday before the killing. Because here's a situation where Lyle Menendez is threatening to embarrass his father by revealing the sexual abuse, and the actions which Lyle Menendez's father take from that point on are interpreted within the light of those prior threats to kill. This is not a situation like Eris, where the defendants claim a remote threat.
No, Ms. Eris said there was a threat that night, didn't she?
Well,
In the first line of the opinion.
That's the key. It's the proximity of, it's the imminence of harm. It's the distance.
The second paragraph of the statement of facts. On the night of the killing, defendant testified that her husband beat her and threatened that he didn't think he was going to let me live till the morning. She believed he was very serious.
Right, and then when she comes back to the house after getting the handgun, the only testimony at that point is, and this is on the next page, I then sat down on the bed and I felt that I had to do it. It would be worse when he woke up. And the implication of that testimony to me is she's sitting at the side of the bed thinking, when he wakes up, he's going to kill me. And so at the point in time when she's sitting there ruminating at the side of the bed that, gee, he's going to wake up, and he had said when he wakes up he's going to kill me, she pumps five rounds into his back. And I would say that that's significantly different here because there's no indication in the evidence that Lyle Menendez or Eric Menendez said that they believed that the threat was going to take place in the threat to kill was going to be effectuated in the near future. The testimony is clear that their belief was that it was happening now. And I believe, at least insofar as Lyle Menendez is concerned, Ms. Lansing clarified, when did you think the threat to kill, when did you think the threat was going to be effectuated? And he said then. So I think that is a factual distinction between the Aris case, because the way the defendant testified in Aris made it seem like the threat was remote in time, remote in the sense that it was going to happen when the victim woke up, and you don't have that testimony here.
Are you saying that the only time the reasoning in Aris would apply would be when the victim was asleep?
No, I think the reasoning applies to a situation where the defendant's own testimony does not indicate the imminence of the threat. And I'm asking the court to contrast the testimony which was presented here with what was presented in Aris, where the defendant apparently, by her own testimony, admitted that the threat was only going to take place when he woke up. So there may be other situations where the defendant, whether the victim is sleeping or not, I think the key point is, what does the defendant testify as to the imminence of the threat? If it's threatening to occur, then the self-defense instruction should be given. If there's some remoteness to it, then it should not. And I think that's as far as one can read Aris.
Well, a defendant testifying that something is going to happen, if believed, establishes the defendant's subjective belief.
True.
There is still an objective standard in California. The defense, in its brief, cites the court to the law of the state of Washington, which is different than this state, although the defense seeks to equate the state of Washington's substantive law with that of this state, and infer that California has adopted the subjective approach that the state of Washington has, although from my reading of the case law in the state of Washington, that state doesn't have the imperfect self-defense law that we have in California, or it appears it does not.
I think the standard is exactly the same. In fact, the court in James, that's a case we cited to the court, quotes their self-defense statute, which is verbatim the same statute as California.
Well, the statutes might be the same, but the Supreme Court's interpretation is substantially different.
I don't think so, because I think the court says it's objective, subjective in the sense that the objective standard takes into account the individual circumstances of the defendant. In other words, in judging objective reasonableness in Washington, the jury is required to place itself in the shoes of the defendant and consider the circumstances in which that person found himself, and specifically the abuse history. And that's exactly the same standard that California has.
California doesn't have that standard. Aris says we don't. That you cannot use the abuse aspect as a factor to be considered. You have combined all the history of abuse and the expert testimony with prior threats, and you combine it into one big conglomeration of evidence and say it all must be considered by the trier of fact, and the trier of fact must be placed in the position of a person who has experienced all of those things. And
Correct.
That is not the law in California. Otherwise, you would have a purely subjective standard of proof. And there would never be an objective reasonable man standard in California.
Well, that's where we come to the cases we cite to the court, which is Pena and Bush and Torres.
Those are threat cases, not cases dealing with history of abuse and the psychological effects of abuse that has been offered by the defense. The court indicated that evidence would be received as to the subjective aspect of the defendant's belief, not as to the objective aspect of the law of self-defense.
I think Ms. Abramson wanted to say something, and it's hard for me to concentrate when that...
Well, if you had something that you wanted to respond to my remarks,
well, I do,
Mr.
but
Burt,
I'd like to defer so that I could concentrate on what I'm trying to argue to the court here.
Well, I'd like to finish off on one subject at a time.
Well,
The same subject.
the only thing I wanted to point out to the court is in the Pena case, when they're talking about whether it was error not to instruct on antecedent threats, the court says, suffice it to say that other reasonable men would view the victim simply as another patron. The victim's entrance and approach would lack the import perceived by one aware of antecedent threats. A defendant's knowledge of uncontradicted antecedent threats must therefore be taken into consideration in the determination of the reasonableness of a belief in the necessity of self-defense. And if that's the law, then that directly corresponds to the law in Washington. Whether it corresponds to the law in Washington or not, it's not really the point here. I think the point is that California self-defense does have subjective elements. Perfect self-defense does have subjective elements to it. And in fact, the Calgic instructions on self-defense talk about viewing it from the perspective of the reasonable man in the same circumstances.
But that doesn't put the reasonable man in the same life history of the accused. If you did, then you wouldn't have a reasonable man. You would have a totally subjective standard that is based upon the defendant's state of mind and nothing else, and that is not the law in California.
Well, then I don't see how the court can reconcile that statement with these cases on antecedent threats, because how can you instruct the jury that they must take into account antecedent threats, which are unique to the life history of that defendant and his relationship to that victim, and still have a purely reasonable man standard? It's our position you cannot, and that these cases stand for the proposition that there is a subjective element, and that subjective element comes into play in this case because the history of abuse is really indistinguishable from the antecedent threats.
Well, I think the distinction is that California does have imperfect self-defense and Washington does not, and that the area that you're addressing is dealt with in the imperfect or incomplete self-defense. Let me hear other counsel's views on the subject.
All right, Your Honor, I disagree with my co-counsel's characterization of the law in California, and I also disagree with him with respect to what the history of abuse and how it interacts. And here's how I analyze it. I agree with the prosecutor that the Aris court had some logical flaws, and I'll get to what those are. But I think where it was not flawed was the notion that abused people may misperceive things as a product of the abuse, but nevertheless are acting in good faith. And so I agree with the Aris court that the history of abuse, to the extent it leads to misperception, is nevertheless relevant and admissible on the issue of a defendant's good faith belief. And good faith belief is the first step in both imperfect and perfect self-defense. However, in reconciling Aris with Pena and Bush and Moore and Torres and that line of cases, I think we're not talking now about a history of abuse as producing misperception, but of special knowledge of prior threats, which has nothing to do with whether the defendant has been damaged by abuse or not, and is no different for abused people than it is for non-abused people, such as Pena, for example, in the Mexican Village case. In that respect, California law says when there is a history of prior threat, a threatened person in this state can act sooner, which has to do with the issue of imminence. And it is not the Washington standard, which means that all the perceptual evidence having to do with abuse bears on imminence. It is a more objective standard, but it is still a standard that says, if you have been previously threatened by someone, if you are familiar with their animosity towards you, if you have reason to believe based on your individual history with them that they are about to carry out a threat, you need not wait the same as a stranger to be acting reasonably. And I think that's the key to the California cases. Now, in our particular case, Your Honor, this is not a case in which someone who has suffered years of abuse simply decides, I am psychologically blown, I can't take it anymore, this is a form of death, and therefore I'm going to kill or be killed before the next cycle of violence begins. Okay? In order for that kind of case to benefit from to be appropriate for an objective self-defense instruction, yes, you would need the kind of standards that Washington State has. But this is not that situation. This is a case where there is an ongoing argument. This is a case where there have been threats of death as interpreted by the defendants, and that bears on good faith. But threats of death, which now bear on special knowledge, over the course of that entire weekend. And this is a case where, like Pena, these defendants knew enough about the people threatening them to know that they were violent people, to know that they were the kind of people who would act violently to protect what was nearest and dearest to them, which was their values of success and winning and status and public perception. So the only thing that the abuse history here really has to illuminate is the good faith of these defendants. But the fact that there were prior threats, the fact that there was threats within minutes of the killing, and the fact that the parents were in a position, as far as the defendants or anybody else outside that room would know, to act upon those threats, implicates California's objective self-defense rule. When the court asked the question, do you have to be asleep then? Is that the only time when it would be appropriate, when one could clearly say a threat is not imminent? I could think of many other examples. If Mr. Pena, for example, or if these defendants, for example, believed their parents wanted to kill them, but believed that it wasn't going to happen until Tuesday at 1:30, then acting Sunday night would be acting unreasonably. But the question is for the jury as to whether or not, given threats to kill by these parents, violent actions in the past by these parents, and an escalating series of threatening behaviors by these parents, which were interpreted by the defendants in good faith, because we don't get to the next stage unless the jury believes that, as threats to kill, were they absolutely acting unreasonably in the sense that the threat could not be perceived to be imminent? I think the court would agree that you could not say that what they were threatened with was death, that it was unreasonable for them to believe, or that there is no evidence in the record for the jury to consider whether the threat was death. I don't think that's the part of the self-defense law that we're concerned with. I think the question is, could you say as a matter of law absolutely that they were totally unreasonable in believing that the threat of death or rape or bodily harm was imminent? Now, here is where the Aris court went off. And Mrs. Bozanich is right. If the Aris court really meant what they said about imminence, they could not have approved the imperfect self-defense instruction in that case, and here is why. An imminent threat does not have to be proven to be actual, factually true. That's not the law of self-defense in any event. A defendant need not have to show that in actual fact it was imminent. Because if that's true, then self-defense would not be available to anyone unless he shot second. It would not be available unless in the shootout.
Okay, we know that part of the law, so you can go out to the area and dispute here.
All right, so we're only dealing with the notion of whether it could have been reasonably apparent to these defendants with a history of threats and violence from these parents who are awake and capable and strong and have now secreted themselves whether they could believe that short of their taking action, nothing would stop a lethal assault on them by their parents. And that's where I think it all boils down to the notion of what does imminence mean. And imminence does not in this state and should not mean immediate for all of the reasons that are in the briefs that were filed. Imminence simply must mean unless you do something, it's going to happen, and it's in operation now. It is in motion. And that was their perception. Now, to analogize it to the Aris situation, Mrs. Aris is sitting on the bed and she is holding a gun. And so she has no reason to believe that she is about to die because Mr. Aris may never wake up. But the situation in that case may have been very different if Mr. Aris did wake up and said something threatening to her. Or
Well, you
made a
know
motion.
Mr. Aris was going to wake up at some point until he was killed.
But she is sitting there
Is that any
protected.
different than the defendants knowing that the parents would come out of the room at some point?
Yes, it is different than knowing, because they did not know in what condition the parents were going to be coming out of that room or how they'd be coming at them, whereas Mrs. Aris had Mr. Aris in full view. She had the absolute advantage of having a loaded gun in her hand, and she could see the precise moment when his eyelids fluttered, if that was the issue.
Well, wasn't that all the situation the defendants had when they walked out of the house, reloaded, came back in, and walked to the door was still closed?
No, Your Honor, and the reason why not is because they are in that state of terror and fear, okay?
Okay,
Which
that's, again, is that a reasonable?
Yes. I mean, that's for the jury to decide.
No,
whether-
that's first for the court to decide whether there's some evidence that would justify the matter going
Well,
to
we
the
have
jury on that
certainly
issue.
put evidence in that it is reasonable when people have tried to kill you and you are truly frightened, it is reasonable to act in the fight or flight mode.
Okay, that, again, goes to
That
the
is
good
reasonable
faith
behavior.
aspect of it, not
No.
to the reasonableness of it.
No, Your Honor, I think that the whole law of self-defense, since we do not require a duty to retreat, isn't it always, Your Honor, more reasonable to leave if you have that option? One could always argue that unless you escape from a threatening situation, you are not acting reasonably. But in this state, as a matter of policy or an understanding of human nature and the fact that people can't always choose which of these panic reactions they're going to engage in, the rule is you need not leave, you need not flee, you may defend yourself. Now, Pena could have gotten off the bar stool at the Mexican Village. He was surrounded by other people, and his assailant was a good distance away, and he had not seen a weapon, and yet he was not required to do any of those things before he acted in self-defense. And the same is true here. The jury may decide it was unreasonable for them to have acted when they did. They should have waited till the parents walked out the door with their own weapons. Or they may decide that given the circumstances of prior threats and given the secrecy and the peculiarity of the parents' behavior that weekend, it was reasonable for the defendants to act as they did. Or they may decide that a reasonable person is not a superhuman person. A reasonable person is a person who uses rationality and logic when those functions are available to them as a person, and is also a person who responds to the autonomic nervous system when that is the only response you can expect, or is a person who responds to the actions of the limbic system because you cannot override those things.
All those things go to a subjective reaction, not to the reasonable man standard. It's not the reasonable man standard.
Well, Your Honor, I do not think that is true. Even under a reasonable man standard, we take it to, I mean, look at the notion of heat of passion, for example. I realize that's a different set of instructions, but the point is you're acting reasonably when you panic. There's nothing unreasonable about panicking. All people panic. You're not a peculiar person for panicking. And you're acting reasonably when in a panic you can't think any more clearly than survive.
The question is, would a reasonable person in that situation have panicked? Not a person who's suffered abuse over a period of time that's caused somebody to have the type of central nervous system response that your witness described. That creates a subjective approach, not the objective approach of the reasonable man in that situation, having been faced with the threats, not with all this prior history that you're talking about.
All right, but prior history of threats, yes, Your Honor.
Only the prior threats.
All right, so the question is whether a reasonable person would panic when faced with a prior history of threats from childhood and when faced with the knowledge of how important to these parents it is not to reveal a secret, when having threatened to reveal a secret and been both attacked and threatened in response. Now, a jury would have to say, and this court would first have to say, it is absolutely unreasonable for these defendants, when faced with these parents, now Pena's not faced with an unknown either, this is a given person of violent, threatening propensities, to have to say that it is inconceivable that any reasonable person would think that with this escalating series of moves within this family, with the threat to reveal the secret, with parents who have always been private and secretive, and that's not subjective on the part of these defendants, that's testified to by dozens of witnesses, one would have to say it's unreasonable to think they would kill to stop that. It's unreasonable to think that they're ordering Eric up to his room, that they're telling them they're not going to leave, they're secreting themselves in the den, is not immediately preparatory to their taking action against their sons. And I don't think that that's the province of this court to say that. The heiress court can say that a sleeping person, when the defendant is sitting there armed and in a position of superiority at that moment, that the threat could not be considered imminent. But once the chain of event is set in motion, I think it is improper and unreasonable to say, okay, now you're racing in a panic to defend yourself, but you should have stopped at the doors to the den, or you should have stopped when you ran outside. I think that is asking people to behave not only in unreasonable ways, but in non-human ways. I think the only time that it's appropriate to analyze the reasonableness of the defendant's actions is at that moment on the staircase, when after this escalating series of confrontations with the parents, they perceive a clear threat to their lives. And it isn't a threat of tomorrow, it's a threat of right now. And in order to prevent that threat, they raced around and took certain actions. And I think this court cannot say as an heiress that the situation was totally calm and totally controlled by these defendants. They have no way of knowing how or where and in what manner the parents are going to come at them. I mean, we've seen a floor plan of this house as well. Those doors aren't the only way that people can get in and out of that room. There are many other ways in which they could have been attacked by the parents. The real issue here, though, now is not whether we have convinced this court of self-defense. We, after all, did not waive jury. Not entirely stupid here. But the question is whether there is any case authority in this state that says that short of the unique situation in Aris, one could say as a matter of law that it is absolutely unreasonable to believe there is an imminent threat. As I've said, I don't think there's any question with the nature of the threat as they perceived it to be. The only question is, were they acting reasonably in believing it was imminent? And reasonable does not mean were they right. Clearly they were not.
Okay, we don't have to go into the area of law that is not in dispute.
All right.
All right, you proposed certain theories as far as the objective and subjective elements of the evidence offered by the defense. Did you propose any instructions along those lines that would deal with how the jury would distinguish between the evidence offered by the defense in that regard?
I'm sure we can.
Have you? Have you thought of that, or is this something that you just bringing up?
I don't know, Your Honor, because I had not been doing it. I certainly didn't bring up this argument. I've made this argument in many cases before and in front of the legislature as well. But we can easily submit
that's a good place to do that, to the legislature. But this court has to deal with the existing law and the definition of imminent danger that has been set forth by the courts of the state.
I could, by 1:30, Your Honor, have an instruction that would distinguish these elements.
Well, I'd like to see what your proposal would be in that regard, certainly.
Your Honor,
yes, let's hear a response from the prosecution.
what the defense is doing is commingling special knowledge of antecedent threats as outlined in cases such as Pena with particular misperceptions of the defendants in this case, which was the subject of expert testimony. And they've commingled them to the point that they've tried to blur the line between situations such as Pena and situations such as theirs, in which the testimony of an expert is necessary to explain why this particular conduct, which appears to be so unreasonable, could be, in fact, be engaged in by people because of their prior experiences. In this particular case, there are no antecedent threats which are of the strength and nature as those in the Aris case. These particular defendants on occasion were told that their father would kill them. But those particular threats were many years before, and in addition, those threats were never accompanied with the kind of beatings that Mrs. Arras took. And immediately prior, and that would be even in the day prior to the murder of Mr. and Mrs. Menendez, there were no threats of death and there was no beating which preceded the threats of death. So the antecedent threats and beatings and the special knowledge of the defendants are inapplicable to the factual situation in which the defendants found themselves on August the 20th, which is why those antecedent threats and special knowledge are irrelevant, and it's why the defense needed so many experts to come in and try to explain why that which looks so peculiar is understandable. And so it's the people's position that cases such as Pena and antecedent threats are really not applicable to this case because of the fact that those threats and any violence in the past were not repeated in the 24 hours preceding, or even starting on the 15th of August. None of that preceded the killings of Mr. and Mrs. Menendez, and therefore there's a distinction here. And I'd like to point out again that Mrs. Arras was beaten right before her husband fell asleep, and he said, "When I wake up, you're dead." And that beating was something that would put her in fear for her life. In this particular case, what preceded the murders was a closing of a door. There was no threats, there was no violence that preceded that, and therefore, factually, this case is distinguishable from cases such as Pena. I think the purpose of the defense experts was to try to explain that which appears to be inexplicable in terms of the defendant's conduct. And that is why the perfect self-defense should not be given, because these lines of cases deal with antecedent threats which occurred later on, and in our case, the antecedent threats do not track what occurred in the days and hours preceding the murders on August 20th.
Well, Your Honor, I think counsel is conveniently forgetting many facts. First of all, my client was attacked with a knife 1 year before this and threatened with death. He was attacked Thursday night by his father, who reminded him that he had threatened to kill him if he ever told. And Lyle was also threatened by his father that night, told in effect, I mean, there are no specific words of threat that have to precede an act of self-defense. But Jose Menendez told Lyle, you chose your course and Eric chose his, which was a very ominous thing. And I think anyone knowing Jose Menendez, not just his sons, would find it ominous. Jose Menendez banged on his son's door Saturday night, clearly angry and upset with him. And the bottom line is, immediately preceding the defendants taking action to defend themselves, Jose Menendez ordered Eric up to his room and said he'd be there in a minute to deal with him. And I don't think, given the history of this family and given the history of his behavior towards Eric and his using sex as punishment in the last 3 years before he died, that anyone would consider it unreasonable for Eric to anticipate another attack, at least as similar to the efforts that Mr. Menendez had tried to make Thursday night. But more importantly, the fact that all of this information in this, that everybody knew, if you will, and that these parents still did not feel compelled to talk about things with their kids, indicated their incredible sense of power over their children. And I think ordering Eric to his room and Eric going up those stairs, Jose Menendez still believed he had complete and total power and control over Eric. I think Eric recognized that that's what his father felt, and therefore Eric's belief that what awaited him at the top of the stairs was an act of sodomy was not unreasonable. It fit the pattern of how his father controlled him before.
Was it imminent, as defined in Arras?
Well, but you see, that's where Arras messes up, Your Honor. In Arras, imminent means actually about to happen in a factual sense.
Well, when you say it messes up, it says that's the accepted and long-standing law in California, and if Mrs. Arras was sentenced to 15 years to life in state prison for second-degree murder, and the Supreme Court had an opportunity to review that opinion and denied hearing.
But the point
so that's the law of this state.
I understand that, Your Honor, but they said that same imminent standards applies to the Flanell defense, and yet he's just as asleep when the Flanell instructions were given in that case, and the court approved the giving of those instructions.
Could I add one
that's
thing?
Still the law as far as the definition of imminent danger, whether the defendant benefited or didn't benefit from the Flanell instruction.
Well, but
Could I add one thing factually when you're done?
If we change imminent now to mean immediate, is 1 minute imminent? If the father had said, I'll be there in 2 minutes, would that not be imminent? I mean, I think the problem is, the real issue is whether the events are in motion and will not cease to be in motion absent intervention and effort on the part of the threatened party to
Doesn't
stop.
closing the door cease any motion?
Oh, no, I mean, the way, you see, the importance of the expert testimony was that it explains the defendant's hypervigilance in reading of pleas, not
Okay,
that...
now you're going again to the subjective standard.
It has to do with their good faith belief.
The subjective standard of good faith belief, not the reasonable
But
man.
good faith belief in the danger, not in the imminence. The point is, closing the doors where the parents are now behaving, have taken a place of concealment, if you will, and yet prohibited their children from leaving the house, okay, does not stop the notion of imminence. It's what put the last match to the fire of it.
All right, Mr. Burt, you want to
Yes,
say?
just to respond factually and to add what Ms. Abramson has already said, and viewing the circumstances from the objective standard that the court seems to be focused on here. Thursday evening, during the confrontation with Jose Menendez, Jose Menendez tells Lyle, this is at page 14568, don't throw your life away, just stay out of it. And that's in reference to don't throw your life away by revealing the sexual abuse and stay out of it. Late Saturday evening, when the brothers come back from UCLA, this is following the fishing trip, there's a confrontation with the mother who lets them in the house, and she turns to Eric Menendez at that point and says, if you had kept your mouth shut, things might have worked out in the family. And both brothers testified that in the context of this series of confrontations, to them that meant that the decision had been made that they were going to go ahead with their plan to kill the brothers. Sunday morning, Lyle Menendez learned of the confrontation which had taken place with Eric Menendez Saturday evening after the words spoken by the mother, in which the father had been pounding on the door. And Lyle Menendez testified he couldn't have been more nervous because of learning of this incident with the father and his mother's comment on Saturday evening. And then Sunday, Lyle Menendez goes in and attempts to engage in conversation with his father about a tennis camp over in the marina. And the father says, what does it matter anymore? Lyle Menendez also testified that he later learned in the day that Mr. Menendez had lied to a friend of his about Lyle Menendez being home, and he testified about the significance of that lie was that the father wanted him home that night so that he could kill him. And there was also testimony that Jose Menendez, through an example, preached a philosophy to both brothers concerning the Chinese students who were rebelling in China, and indicated to him that his philosophy was just acquiesce and then kill them. So these are circumstances from which a reasonable person, given the antecedent threats, could say that an act of acquiescence by Jose Menendez, such as going into a closed room, immediately after a confrontation in which Lyle Menendez was saying to the father in the presence of the mother, you're not going to touch my brother anymore, indicating that he was in fact going to carry through on his threat to reveal to the world that Jose Menendez was committing this sexual abuse. At that point in time, given the entire history and the threats up to that point, his turning and saying, come on, Kitty, and going behind closed doors, I think distinguishes it from a situation such as you had in Eris, and certainly is not a situation where the court can say on those facts, I have no doubt as to the insufficiency of the evidence. That series of confrontations and that history of threats can give me no doubt that there is insufficient evidence here to justify a reasonable self-defense instruction. And that's the
Eris definition of imminent danger.
And I think that's under the Eris definition of imminent danger. That's not trying to incorporate subjective elements into it other than the antecedent threats. And that's staying strictly within the definition of heiress, of imminence, and also taking into account the point that Ms. Abramson made before, that it is imminence is also defined in the Calgic instructions. This is 5.30. The last sentence says, necessary to prevent the injury which appears to be imminent.
Exactly.
So appears to be imminent is a slightly more flexible standard than actual presence of imminent. It is.
There doesn't have to be actual danger, and that's the law, but whether it's actual or apparent, it has to be reasonable for the perfect self-defense. The belief has to be reasonable.
I understand. My only point is the standard as incorporated in the jury instruction is appears to be imminent. That is, and the heiress definition can be incorporated into that, appears to be about to happen. It's not, is it about to happen? It appears to be about to happen. And in light of the entire history of that week, taken in the context of the history of the antecedent threats that are revealed in this record, it at the very least would appear to a reasonable person faced with these circumstances would appear to be imminent, or at least a jury could so find.
May I add something also, Your Honor? Just in terms of prior threats, I think that the court cannot view these last few days in a vacuum, and I think that there is a history of both verbal threats and threatening behavior by the parents throughout the life of the children as they grow up. Certainly, there's been testimony that Lyle was threatened by his father during the periods of his abuse, that Eric received similar threats from his father during his own abuse. We have Lyle talking to his father at 13 about Eric's abuse and receiving threatening warnings then about the secret getting out. Mr. Burt referred to the incident with Brad Werner, who was the tennis coach, in which Jose Menendez hit Lyle in the face.
Yes, I remember that.
That was Brad Werner, not Robbie Klaus, and said,
Yes.
if you ever embarrass me again, I'll kill you. We have the incident with Craig Signorelli in front of a number of people in which Jose Menendez threatens to kill him if he doesn't stay away from his family. We have the separate incident with Robbie Klaus, in which the father threatens him, Robbie Klaus, then a 35-year-old man, threatens him with regard to putting any ideas in Lyle's head about turning pro, and Robbie Klaus is frightened enough that he stops coaching him and passes on the message to Lyle Menendez. And during the last week, in addition to everything that Lyle Menendez has witnessed throughout his life in terms of his father's fearlessness and him bragging about his interaction with business associates, watching how he behaves around friends and relatives, there's these series of statements which are very threatening. In addition, they have the history of the mother's rages and her threats to poison the family. So there is a lifetime of threatening behavior in which these last few weeks occur, and I think it's impossible to separate out the two in terms of someone's perception of reasonableness. And there's something else I'd like to call to the court's attention. Whether it appears totally reasonable or unreasonable to this court that they would have believed that they were going to be killed. As the court knows, we all get hundreds of letters, and there are hundreds of people out there who have watched this who say there's no doubt in their mind that Kitty and Jose would have killed their children. Now, whether they're right or wrong, they are certainly, people out there in the public who see things differently than this court does. And
well, bear in mind that the law of self-defense and how it's developed and the restrictions on its use have a very substantial foundation in our law that one person doesn't have the right to take the life of another. Your focus in defending people accused of crimes is always on the defense as to the defendants and their rights. But the law is that everybody has a right to live, and there has to be substantial reason before any person's right to live can be denied. And that's why there are limits on the law of self-defense. So what some emotional reaction might be to evidence that's been presented and how people react to it based on their own personal lives or background or whatever is not the point. The point is there has to be some objective standard in order for the law to be applied in self-defense.
I understand that, but my point with regard to the letters are that there are a great number of people who believe that Kitty and Jose Menendez would not have let the secret out, who believe they would have killed. And so it's not a question of whether they know the fine points of the law or not. It is their reaction to the factual material that's presented that they were going to kill. Now, clearly,
I think you could focus on something more substantial than counting letters. It really is not helpful to me.
It is helpful in that we are suggesting, or I am suggesting, that other people may see it differently than the court, and we only want the opportunity to have this issue judged by the jury.
I understand that. That's what we're discussing. That's the issue that the court is addressing, permitting counsel to present your views as to whether there has been substantial evidence presented that would justify instructions on this area of law. And we're familiar with the rules that apply in that regard. There's various cases that talk about the standard of evidence that must be produced or in the record for instructions to be given on the law. And if and when we get to a completion of this discussion, I will recite what that standard is. Yes?
Oh, I was going to say, Your Honor, that I agree with the court with respect to the notion that there is obviously a very strong societal policy in effect that underlies the law of self-defense in this state, in every state. But there is also an awareness of, most of our rules about self-defense in the state were written in the 19th century, and were written for envisioning a situation basically where you have adult males in conflict with each other, and were written with the notion that the requirement of imminence was to make sure that trigger-happy gunslingers, basically, or fellows engaged in barroom brawls, did not take lives of other people without every reason to believe, and I think that's where the word reason comes from, but every reason to believe that that's what was necessary to stop a lethal assault. And when you're dealing stranger on stranger, you really can't know whether a person is really going to harm you except by examining their actions. And I think the concept of imminence was introduced, or was a notion, in order to prevent people acting sooner than the intention of their adversary by action could be known. Now, that's fine in stranger-on-stranger conflicts, but I think it is not an adequate response to say that the law of self-defense in this state then only works for people in those kinds of conflicts, and we will leave for other groups and classes of people than adult male strangers manslaughter with 19 years in prison rather than justifiable homicide. I think the point is that Flanell apart, the law has to gain recognition, and has gained recognition, first under the series of cases dealing with antecedent threats, and then by the introduction of the notion that's encompassed in 1107, that there has to be a greater understanding that when the adversaries are basically unequal, and when the history between them is more than you could ever explain in stranger-to-stranger confrontations, then you cannot say that people behaving in the context of a lifetime history are per se unreasonable if they act before
1107 of the Evidence Code doesn't say that. 1107 of the Evidence Code just says that this evidence may be received. Doesn't say how it should be used, or it doesn't say, and it certainly doesn't create, this whole area of law of battered women and battered children does not create any legal defense.
But it does recognize that there are psychological realities that exist between people who know each other that are far more complicated than those between strangers. Or, I mean, that's the fundamental notion behind 1107. And the problem is that the only way that courts apply self-defense is to deal with the stranger-on-stranger, adult male, everybody's even situations, then a vast number of people are being discriminated against by this law for no sound policy reason.
No, but the other side of the question is, again, how does one deal with the subjective element that is introduced by expert testimony regarding battered women or battered children? You then set up a different class of people who have greater rights than others because of their subjective beliefs.
They wouldn't have greater rights, Your Honor, if you... No, and I'm not arguing for this in this case because I don't really think it's necessary in this case. I think there is enough antecedent threat evidence in this case and enough behavior on the part of both the defendants and the victims in this case to justify a reasonable self-defense. But to answer your question, there is a reasonable battered person standard as well. The notion that you can't write your own rule for yourself as a unique individual and say, I was acting in good faith, therefore I'm reasonable, is one that no one is quarreling with here. But it doesn't create greater rights for battered people if they act reasonably within the context of what has happened to them and are acting the same as all other battered people would act under the same circumstances.
Well, but the
That doesn't give them
circumstances of each
greater
case
rights.
is different because you, in essence, have, as you presented here, the life history of each defendant, and what you propose, or at least Mr. Burt proposes, is for the jury to put themselves, or each individual juror, put him or herself in a position of having experienced everything that these defendants experienced in their entire lives.
Let me give the court an example, just to distinguish that we are not arguing for a subjective but rather an objective standard, and here is the difference. As you heard in this trial, whether it's believed or not, but there is a great deal of research now in the notion that children can be grievously harmed by psychological abuse. And let us assume we have a family in which the only form of abuse was psychological abuse, and there was never a threat to kill for any reason in that family. And yet you wind up with children who have many of the perceptions, many of the perceptual anomalies, if that's what they are, and the hypervigilance and the hyperattentiveness of other battered children. Okay, well, there has been no history of lethal threat in my hypothetical family. Okay, I think then, if a child of that hypothetical family were to claim a fear of death at the hands of those parents, there has to be an analysis of what was the antecedent behavior in that family, and a court could say it is absolutely unreasonable for this child to have believed he was threatened with death based on this behavior of these parents, because there never was any lethality to the behavior of those parents or any violence. So I don't think that just because in other words, we're not asking that all abused people can write their own standards. All we're saying here is that this is a case with simply a long-term history of antecedent threats of one type or another, but threats of bodily harm or death or rape or other justifiable, other actions in which it is justifiable to prevent them with the use of lethal force. And I think that's all we're asking, is that this jury be given the opportunity to weigh whether, given that history of lethal threats, these defendants acted reasonably in believing that harm was imminent. I don't think there's a dispute here, in fact, as to whether or not they were reasonable in perceiving they were going to die. I think the only dispute is whether they were going to die then. And for that, in other words, whether...
Are you saying that the prosecution doesn't dispute your theory?
Oh, no, they dispute it, but I think in
You
argument...
said there's no reasonable...
I haven't heard the court being concerned about whether or not their perception of potential death...
Well, I'm not weighing the evidence. I'm just evaluating whether there is sufficient evidence to give these instructions to the jury. It's not for me to...
No, I understand, but it seems that what we're
evaluate the credibility of witnesses here.
No, I understand that. But I think what we're talking about here is whether or not, as a matter of law, this court could say there's no evidence to support the notion of imminence, not that there's no evidence to support what the harm that was perceived would be. I don't think the court has even suggested that there is no evidence in the record that the harm that they were afraid of was the harm of death. I think the issue that keeps coming up is whether it was imminent, and I think the problem is, if the cases that deal with male-male antecedent threats or male-female pure antecedent threat evidence say, as they do, a defendant faced with an assailant where there is a history of threats and violence has a right to act more quickly than one who does not. And I think the policy behind that is because if you know the person and you know that they threaten you, you're not jumping to conclusions or misperceiving the situation because you have special knowledge. If there are those cases in California, and there are, I think it is very dangerous, if you will, for courts to start getting involved in drawing the line about how quickly is more quickly. And what does a closed door mean to the court versus what did a closed door mean to these defendants, or what would the closed door mean to the jurors? I think it is even possible that there can be a case of a sleeping victim where Aris would not apply. And so if being asleep is not enough to say in all cases a sleeping victim, it could not be imminent with a sleeping victim, and I'll give you my example. I think it's much, you cannot say in all cases, because the potential victims who are awake and alive and behind closed doors are behind those closed doors, that the threat of death could never be imminent. And I think that's what it boils down to. I mean, you can envision a victim who is asleep but rigged it up in such a way that the second he flutters, the gun's going to go off and blow away wifey.
I could use my imagination to come up with all sorts of theories.
Yes, I'm sure you could.
All right,
Could
yes, very brief.
Yes, the court had asked how the defense proposes to distinguish for the jury the difference between the objective and subjective standards, and I think that the cases cited to the court point the way in that regard, because
Okay, if you have something specific in mind, you can put it in writing and present it to me when we resume.
Well,
as far as an instruction, if you have such.
It's just a general statement as to.
Well, if this is something that you intend to pursue as part of your presentation to the court and or the jury, then if it's something that is going to be to the jury, then it would have to be by way of instruction.
No, I understand, and it's an instruction that's already before the court. That's why I wanted to point it out. The Torres Pena line of cases indicate that the court, on request, in a case of perfect self-defense, should instruct on the antecedent threat issue.
Right.
And those instructions have been proposed by the defense. The prosecution has submitted an instruction based on Aris, which seeks to limit the expert testimony to the question of subjective reasonableness and, subjective belief. And Aris says that in a case where the court gives perfect self-defense instructions, that a limiting instruction should be given, indicating that expert testimony is relevant only to prove the honest belief requirement for both perfect and imperfect self-defense, not to prove the reasonableness requirement of perfect self-defense. So I think in combination, the prosecution's request and the defense request do serve to outline for the jury what is and is not a permissible use of that testimony.
All right, any other brief remarks?
Yes, I have a brief remark.
Yes.
In this case, there is no history of life-threatening violence against these defendants. They were never taken to the hospital, having been beaten to within an inch of their life. And if Mr. and Mrs. Menendez had been engaged in any conduct which a reasonable person could construe as life-threatening prior to their murders, then I think the defense would have an argument that self-defense should be given. But given those two failures in this case, there is not substantial evidence to support the giving of self-defense instructions.
All right, we'll resume at 1:45. The court has reviewed the evidence presented. I've reviewed it quite extensively, both as it was presented and as it's been presented to me in this phase of the trial during discussions of jury instructions. And the issue is whether there has been sufficient evidence to justify this self-defense instruction, the perfect self-defense instruction. Having reviewed the entirety of the evidence in this case and recognizing it's not for the trial court to determine the credibility of witnesses or to evaluate the strength of the evidence, but just to make the threshold decision as to whether there has been sufficient evidence put before the jury to justify an instruction on this concept of self-defense, perfect self-defense. It's my view, after reviewing the entirety of the matter, that there simply is no evidence of the objective standard of reasonable belief in the imminent danger of death or great bodily injury or the attempt to commit an atrocious felony to justify giving the perfect self-defense instruction in this case. The defendants, by their own testimony, had other means to deal with the distant threat that they say they perceived. They could have done other things. They could have left. In fact, they did leave the house. The argument regarding retreat and the law that, and the rule of law that a person who has the right to exercise self-defense need not retreat only exists if the person has the right to exercise self-defense. In this case, there was no objective, reasonable belief that would justify exercise of the right of self-defense. The bulk of the evidence presented to the jury during the course of this trial related to the subjective belief of the defendants, what they actually perceived, which is an element of imperfect self-defense as it is of perfect self-defense. But it did not relate to the objective standard that is a requirement of perfect self-defense. And I don't find that there has been any substantial evidence, any evidence justifying the jury being instructed on perfect self-defense. Therefore, the request to so instruct is denied. And we'll now proceed with further discussions regarding instructions.